thank you everyone for coming to the 8th annual West Virginia Law Energy Moot Court competition. It's been a fantastic competition, lots of competitors. As you can see, we're down to 2 teams. It's been a lot of work, and really appreciate everybody's involvement. Just to give you a brief overview of the problem, and I'll try and be super brief, but this case involves the proposed construction of a liquefied natural gas export facility. Specifically, it asks whether the environmental impact statement was adequate. Here, the 2 parties are Mammoth Cove, Intervenor, and the Planet Protection Group. Planet Protection Group is challenging the validity of the environmental impact statement, specifically as it pertains to greenhouse gases and CO2 levels thereby. But in addition to that, they're also challenging the transfer of property which the terminal will be built upon under the public trust doctrine. The district court denied Planet Protection Group's, you guys are Planet Protection Group, Planet Protection Group's injunctive relief, and now we are at the 12th Circuit Court of Appeals. With that, ladies and gentlemen, Lauren Payne is going to come up, do some brief introductions, and we'll bring out the judges and start the competition. Thank you.
Hi everyone, thank you again for coming. We are honored today to have a very distinguished panel of judges. We have the Honorable Judge Thacker from the 4th Circuit. We have the Honorable Judge Keeley, who is a district court for the Northern District of West Virginia. We have the Honorable Judge Alloway, who is a district court judge for the Northern District of West Virginia. We have the Honorable Judge Albuhazen, sorry, who is a district court judge for the Southern District of West Virginia. And we have the Honorable Judge Volt, who is a bankruptcy court for the Southern District of West Virginia. Our competitors today, whose schools will currently remain anonymous so the judges don't hear it, are Andrew Alvaros, David Diab, Melanie Franco, and their coach Colin Spears. Also Kyle Wood, George Wanze, I practice, I'm sorry, and Jonathan Barsky and their coach Jennifer Franklin. And at that, we should be good to get started.
Oh, yes, you are. All right, do you want us to come out now? Have you introduced it? Okay, we're ready.
Thank you all.
Okay, so Appellant, symbol, and name.
All rise. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give attention, for the court is now sitting. The case of Planet Protection Group versus Mammoth Cove Point LNG LP will now be heard.
Thank you. You may be seated. All right. So first we'll hear from Mr. Alvesparos. Is that
correct,
okay? Is that correct?
Yes.
All right. When you're ready.
Good afternoon, Your Honors. May it please the Court, my name is Andrew Alves-Barros, and along with my co-counselor, David Diab, represent Planet Protection Group. I would like to reserve 4 minutes of our time, 2 from each, for rebuttal.
All right, you may.
Thank you, Your Honors. I would like to see if Your Honors want a brief recitation of the facts.
I think we're familiar with the facts, unless anybody else here needs that. No, you can go ahead with your argument.
Thank you, Your Honor. I'll be arguing issue 1 and 4, respectively, the violation of NEPA and the violation of the public trust doctrine. Your Honors, this is a case where the state did too much and the federal agents did too little. To my first issue, Your Honors, NEPA was violated by the Department of Energy when they neglect and fail to take in consideration the downstream greenhouse gas effect, and also they took in consideration a life cycle report that's coal-based. Meanwhile, the portfolio of the countries that we know they're going to be disposing and exporting the energy are renewable portfolios. So my first issue, Your Honors. Here, the Department of Energy, similar to Sierra Club versus FERC, made a neglect when they make an environment impact statement that takes in consideration a broad view of greenhouse gas emissions that are not even going to be displaced from these countries, United Kingdom and Germany, or at least in lower quantities once that they are renewable energy portfolios. Furthermore, Your Honors, we have here another problem that the
Isn't your argument on this speculative in the end? Shouldn't we permit the DOE to make a decision that they're certainly qualified to make?
Absolutely, Your Honor. They have deference in their as a federal agents, but however, they act arbitrary and capricious in this instance where they did not take in consideration the reasonable foresee effects of exporting gas to renewable.
And what's your best evidence that they didn't take that into consideration at all?
Your Honors, page 6 of our record, first paragraph, and page 8, second paragraph of our record, explain us in detail that those countries, United Kingdom and Germany, they use less than 10% of their energy in coal. Also, they are leading countries that by 2050 are going to be over the 50% margin of the energy based in non-renewables. So here, they are more likely to be replacing the energy that they...
But see, when you say things like more likely, that's where I go back to my question about it being too speculative, your argument.
Your Honors, you are correct. We are speculative, and we would like the Department of Energy to take a hard look, that is what NEPA requires them to do, and go and make a research and a data specific for these circumstances. They fail to do so. They neglect to do so because they did not take in consideration, and they use a life cycle report that was recycled from another case. They used the life cycle report that was used in Sierra Club versus Department of Energy. There, we did not know which...
Well, an agency doesn't have an obligation to reinvent the wheel every time if the data hasn't changed. So was it substantively recycled, or was it just recycled, you know, in terminology?
No, it was substantively, Your Honors, because they did not take in consideration the circumstance of those countries that we know where the gas is going to end up. In their life cycle report, they compare coal countries in overbroad Asia and Europe as continents instead of countries. And the life cycle report was valid when comparing with continents because the life cycle report was a coal-based, and the country and the continent as a whole had also the same level of emission in coal-based.
Why isn't this a political question? I mean, you know, half of our Congress believes that the greenhouse effect isn't even real, that there's no such thing as global warming. How are courts supposed to try and decide this matter if Congress can't even figure out whether global warming is real or not?
Your Honors, that would be a question more further for my
okay, I'll direct it to him. It's coming.
So what are you suggesting they should have done?
Your Honors, simple. Just taking a hard look and take the circumstance of our specific case. For example, a simple analogy shows how absurd and ludicrous it is to use this life cycle report to these two countries. For example, let's say your Honors are trying to read a Greek newspaper, and I offer to help you a German dictionary. That's what they did here, not to help your Honors at all. In the same way, the life cycle report that's coal-based is not going to help us to understand what's the long-term direct and indirect impact of in those exportations in these countries and overall in the earth as well.
So well, go ahead.
I know you don't like the analysis of the Department of Energy in this regard, but it doesn't matter to us whether you like it or not. All it has to be is adequate. What was so inadequate about the analysis as to make it reversible as a matter of law? Or as abusive, I'm sorry, under the standard of clear error?
Yeah, the standard is arbitrary and capricious.
Arbitrary and capricious.
And Your Honor, was arbitrary and capricious because NEPA requires them to make an environment impact statement that is adequate for the circumstance of each case.
Well,
Is a case
that's
by-
my question. Why do you say it was inadequate? I know you don't like it. I know you think they should have done another one. They did one. What about it was inadequate?
Yes, Your Honor. They did not even make a report for this circumstance. So right there, as a prima facie case, they would be failing and violating NEPA because they did not take the circumstance of this case. Rather, they take the circumstance of past case. So right there, they would be violating NEPA. And I would even go further in this line. They did not even provide any statistic of where this gas is going to end up. We know that this gas is going to end up in business in United Kingdom and Germany, but we don't know.
What I saw on the record with respect to these renewable energy sources in the receiving countries, Great Britain, I guess, and Germany, is terms like the renewable energy resources there are more prominent resources, that they're more likely to displace zero carbon. How in the world does an agency quantify that? I mean, this isn't simply a mathematical equation that we plug these things into. The agency has to have some subjective discretion. What is going to change if we send it back and the agency can simply look at it subjectively and say, well, we don't have enough data to make this determination? It's speculation at the end of the day, like Judge Thacker said, isn't it?
Yes, Your Honor, it's speculation, but nonetheless, they're not immune from their duty, which is to go and make a research and bring data regarding those countries. They didn't do this here. Rather, they are just using something that was already prepared before. And to answer Your Honor's question, they could simply go to those countries and make a research in the same way that they did for the content as a whole.
That's the other question I have for you. When they go to those countries, can they borrow data that's already been generated by those countries' agencies or perhaps other interested parties, special interests in particular, or do they have to do their own empirical study on outputs? How in the world does that even look, and what is it going to cost?
Here, for example, Your Honor, the record is silent on whether it was costly or not costly at all. We know that Department of Energy partnered with FERC in these matters, and they were able to do so in less than a year. They got that in 2013, and by 2014, they already had a life cycle report and the data for these matters. So we could assume from this past experience that it will not take too long for them to make another research. And that
If we were to buy your argument, how would we determine what effects are reasonably foreseeable?
Your Honors, exactly, we are not able to determine anything.
No, but isn't that what you're asking us to determine, that there were reasonably foreseeable effects that the DOE failed to evaluate?
Yes, Your Honor. I mean,
so how do we determine that?
Your Honor,
what standard do we apply? Where's the evidence that we're supposed to review that the DOE didn't?
Your Honors, I'll not be able to give you what data they're supposed to be given here, but rather just remind them to our hearing that they deny us in the first place, so they can make the hard look that they're supposed to do in the first place.
So it's not that there's evidence in the record that the DOE ignored. It's that you think that there's evidence that the DOE should now consider that was not in the record before, wasn't submitted by anyone, but that you think if they could find it now, it would be reasonably foreseeable and it would void the decision below?
I would agree with everything that Your Honor said, besides not why I think, but what NEPA requires them to do. NEPA requires them to go and have a hard look and get data for this specific circumstance. And it brings me to my second point, the public trust doctrine here. In the state of Franklin, we don't have a specific statute that have read into the public trust doctrine. Nonetheless, in Shively versus Bowlby, we have that each state of this country, in their statehood, they adopted the common law. The common law coming from England, which had read into the public trust doctrine. And in our case here, because the legislature of the state of Franklin did not revoke the common law, that's the law of the land until revoked.
But what about the fact that the state of Franklin has owned this property since the formation of the state?
Your Honors, the analysis would not change because nonetheless, this land is held in trust for the people of the state to use and enjoy.
And on what do you base that on?
I base that, Your Honors, in Stone versus Mississippi, a U.S. Supreme Court case where the Supreme Court decided that the land cannot be disposed piecemeal for corporate and private ownership. Rather, is held in trust of the state for the enjoyment of everybody. And furthermore,
Let me ask you about the public trust doctrine. Why is it still even applicable? When you look at the case law that out there, they're 125, 126 years ago, and they talk about a time and a place that doesn't exist today. For example, it talks about that the state can't give away navigable waters, just like it can't abdicate its police powers and administration of government and the preservation of peace. Well, we now do private prisons that are clearly police powers. We now have contracted soldiers fighting in war. I mean, clearly that doctrine just doesn't apply like it used to 126 years ago. So why should we not just discard that completely?
Your Honors, that would be a matter for the legislator of the state to do so, not from the judicial branch to do so. Furthermore, in Your Honors examples such as military that are fighting abroad or other private institutions who do the public services, here is different. Here depriving the interest and the rights of people from use the land that their old generations have been using and their kids would be used after them. Here we prevent and barring them for use this river and the riverbeds that was something for the public trust.
But part of it is fenced off. There's a no trespassing sign. You know, those folks are using it at their own risk. The other thing that's troubling about this public trust doctrine is that right now in this country, land is freely alienable. You know, you've got zoning restrictions and things like that, but we've got certainty in our land records. If we adopt this doctrine in gusto or with gusto, doesn't it sort of interfere with that free alienation of land? A sovereign now can't just go sell and have something closing in 90 days. It's got to worry about a lawsuit and a judge making a determination after discovery and probably who knows what else to determine whether it violates the public trust. That just doesn't seem wise from a policy standpoint to interrupt the land transfer policies that we have.
Your Honor, I would like to divide our statements in two parts. First, regarding the trespassing that Your Honor mentioned previously, and the second, whether or not that would affect the alienable policy. In regard to the trespassing, Your Honor, I see my time is up. May I briefly answer your...
Briefly.
So, Judge Thacker, thank you.
Briefly.
Yes. Your Honor, in regard to the trespassing, the state of France themselves recognize that although it's not officially a public park in this area, is in practical matters it is. They even allow people to build picnic tables in this area. Now, in regards to your alienable questions, we'd say that doesn't hurt at all the alienable questions. Rather, just promote a safeguard for the people of the land. Here, they still can alienate.
Okay, you're a little beyond briefly. Could you conclude, please?
Thank you, Honors. For the foregoing reasons, respectfully ask Your Honors to reverse the denial of a rehearing from the Department of Energy and reverse the lower district court. Thank you.
Thank you. All right, Mr. Diab? Diab, thank you.
So you've had some opportunity to consider my question that I asked your able co-counsel.
I have, Your Honor.
So why isn't it a political question that we as judges aren't capable of answering? When Congress can't even, I mean, I come from a deep part of the South that mines coal, and you can't find someone down there who believes that global warming is real. So why are we even bothering with that?
Yes. Well, may it please the court, Your Honor, I'll jump right into your line of questioning. The political question doctrine gives us factors set forth from Baker v. Card to determine whether or not something is a non-justiciable political question. Now, simply because there are government mechanisms in place does not require the judiciary to remove itself. And that is exactly what Baker v. Carr set forth these factors to determine, whether or not this was entering into the political thicket where the judiciary didn't belong. Now, each of these factors, any one of which can be fatal to a claim, does not exist in our case. The lower court dismissed prematurely this case, closing the courthouse doors to Planet Protection Group and its citizens based on the determination of Judge Mars that there was an initial policy decision that was needed that was clearly the kind for non-judicial discretion.
Didn't I just hear your co-counsel argue that this was a question for the legislature and the court should not look at that?
In reference to a state legislator, Your Honor, yes, he did say that it is up to the state legislator to expressly revoke the common law default position of the public trust doctrine. What I was attempting to answer perhaps was the lower court's denial of the due process claims.
But it sounded like your co-counsel agreed that this wasn't a thicket into which the judiciary should leap, but rather to leave it to the legislature to articulate the policy, which we would then review.
It is the Planet Protection Group's assertion that the default position of the public trust doctrine does apply, and the court should not read into their state legislative duty of revoking the public trust doctrine. That following case law that he tried to outline there was that the default position for the state law there should be the public trust doctrine. As it applies to substantive due process claims, the court should not punt to the legislator because none of the Baker v. Carr factors apply in this case. And furthermore, we also ask this court to recognize that there is a fundamental right to a climate system capable of sustaining life.
Well, did you just conflate the arguments? Are you saying that part of the public trust doctrine is the Fifth Amendment substantive right that you've just articulated?
The public trust doctrine at the federal level does implicate a substantive due process right in that the federal government, as its has a trustee fiduciary relationship as it exercises its dominion over the territorial seas.
So are you asking us to decide this under the common law doctrine or under constitutional law?
Under the constitutional issue, we simply ask that this court remand to the lower court. This matter was dismissed at the pre-discovery phase for a non-justiciable political question. We state that the courthouse door should not be closed to Planet Protection Group. The court should be allowed, that the proceeding should be allowed to go through the natural course, and that the substantive due process claim can rely on the similar jurisprudence of Roe v. Wade, of McDonald v. City of Chicago, other traditional substantive due process jurisprudence to rely on in adopting this newly recognized fundamental right to a climate system capable of sustaining life.
But why are the courts better suited to answer those questions than the legislature?
Thank you, Your Honor. The reason why is because there are procedures in place here under NEPA, as my co-counsel mentioned, that would provide the court, under Baker Factor number 2, a judicially discoverable standard. The court here, in recognizing this right, would then be allowing the appropriate agencies at lower court levels to then provide and meet the burden or fail the burden of passing strict scrutiny. The court has recognized newly recognized fundamental rights out of, and I'll use Roe versus Wade as a jumping off point here, enumerated rights.
Wouldn't the court first have to conclude that climate change is real, that it exists, and that there is currently a climate system not capable of sustaining life in the long term? And if so, how are we equipped to do that?
Respectfully, Your Honor, no, this court today would not have to determine whether or not the consensus of climate scientists is somehow also a legal consensus as well, which is one reason why we are pleading with this court to remand to the lower court so that So
that court would have to conclude that climate change is real.
Well, through a traditional discovery, we could put some of these. Yes, Your Honor. Mm-hmm. Yes, Your Honor. And we believe that we could carry that burden here or there.
And you think traditional discovery can solve the issues of climate change?
I think in our case it is unfair to deny Planet Protection Group their day in court based simply on one judge's interpretation without considering putting the expert testimony on the stand. I'll point to you at
What about one judge's decision on climate change, as Judge Thacker said? I mean, this really gets down to competence. I'm not sure you've addressed that yet.
Yes, Your Honor, I would like to address that. It's not outside the competence of the court in an analogous case of Gilligan v. Morgan, in which the Supreme Court found they did not have the competence to address military training of the National Guard. However, the court did state that the military was not beyond judicial review. Here, the court would be able to more competently judge this matter if the agency below had taken into consideration the proper procedure that NEPA requires. We would already start to have a more informed standard from which to judge this on. And I will point you to page 5, footnote 6 in the record. One of the studies that the Department of Energy relies on considered the input of 6 to 12 billion cubic feet per day. The record in page 3 indicates that in addition to the 11 billion cubic feet per day existing, the Department of Energy has approved 4 more facilities that will export 7 billion cubic feet. So we're well over 30 billion cubic feet, yet the data that they've given the courts and the public to judge by only considers not even half of the amount which in reality will be existing. That's just simply not enough for any court to say is a standard by which they can apply, and that's why we ask for, again, the courthouse doors to be left open for this to fully develop a record so that we know going forward that we can establish there is a fundamental right to a climate system capable of sustaining life.
How long would it take to figure that out?
To figure out
that there's a climate system either capable or incapable of sustaining life. We're in 2018 now, and we're still debating that.
Your Honors, I'll draw your attention to the recent District of Oregon case of Juliana. Juliana versus United States, at the similar stage in the proceedings, found that there is a fundamental right to a climate system capable of sustaining life. This court has the opportunity today to further in the tradition which has happened in all the lines of the substantive due process case. There always has to be the first case. There was no Hellerstedt before Planned Parenthood. There was no Planned Parenthood before Roe versus Wade. So for the threshold case has to begin somewhere. And it is the opportunity of this court today to consider with the line of reasoning that the fundamental right of life itself will be put in great peril.
But Juliana didn't directly address the atmospheric public trust issue, did it?
Your Honor, we do not assert today that that the atmosphere itself is held in the public trust. We rely on a more traditional reading that greenhouse gas addition to the climate will and is causing an increase of global mean temperature that is causing the sea level to rise. As the sea level rises, it causes a direct harm to the territorial seas and to the tidal river. We see in the record the Vandalia River has, I believe, 3 miles of tidal waterways affected by the rise in sea level. That is a direct harm. We are not extending a tangential connection between traditional public trust from the time of Justinian.
When you say all that the sea levels are going to rise, from my part of the country, we don't believe that. I mean, this is just normal stuff that happens. I mean, that's why I say, how can we as judges decide this question when there's a whole swath of this country that doesn't even believe that?
Your Honor, I understand.
It becomes political, and therefore we're not capable of doing that.
Your Honor, I will point to a case of Massachusetts v. EPA in which the Supreme Court struggled a little bit with a similar question, and ultimately the holding of that court was to support that the EPA, based on how it's established, did have the duty to then regulate carbon dioxide, yet the court, and I think would agree with your position here, was in no position to, the court didn't set the CO2 guidelines that the EPA then had to implement. The court simply found that the EPA is the agency here, upon finding that CO2 did endanger the public.
Well, one argument is to say we've got to apply the statute that they say here's the level of CO2. Another one, you're trying to tell us there's a fundamental right to an environment, an atmosphere, and sea levels, right? I mean, those are 2 different things completely. One of them is set in stone by the legislature, and here's what the levels have to be. The other thing that you're asking us to do is find a fundamental right in the atmosphere. I just don't see how we can do that.
Your Honor, we can have the court do that, and I will analogize to Brown v. Board was decided a decade before Congress decided to act with a Civil Rights Act.
Well, Brown v. Board required the integration or got rid of separate but equal. But how do we decide what emissions are allowable or not allowable? That's not a role for courts, is it?
Your Honor, we are not asking the court today to set the standard. As in Massachusetts v. EPA, we are simply asking the court today to recognize that.
But you're saying that the standard that the DOE looked at, that the FERC looked at, was arbitrary and capricious?
Yes, Your Honor.
So in order to say, for us to say that, don't we have to look at some standard? We can't speculate to go back to where this all started.
With all due respect, Your Honor, if we had a more informed record, I surely would be able to point to you in a more specific direction rather than a general direction that would inform the court that it was not stepping in the province of the legislature here. The court here has the opportunity before it to recognize a fundamental right that is not outside the purview of the courts under the Baker factors, and in establishing that right can be a step in the chain between what is becoming a more and more pressing subject as the days go on. This could perhaps be the one domino in the chain of events that lead to the final protection that we've assigned agencies already, but it's not far enough. This could again be the chain and the effect that increases the oversight and the applicability of a fundamental right to a climate system capable of sustaining life. And we do not believe that Planet Protection Group should be, that we should have our day in court and be heard, and that was denied at the lower level prematurely before a record could be fully developed. And it is our assertion that by remanding this case, I see my time is complete. May I briefly conclude, Your Honor?
You may.
We ask this court to remand this case and reverse the lower court's hearing. Thank you, Your Honor.
Thank you. All right, we'll hear from Mr. Wood.
Thank you, Your Honor.
Whenever you're ready.
Good afternoon, Your Honors, and may it please the court. My name is Kyle Wood, and along with my co-counsel, Mr. Jonathan Barsky, we represent the interveners in today's case, Mammoth Cove Point. Before the court today are the Planet Protection Group's challenges to Mammoth Cove's legal actions to provide current and future generations with cleaner burning natural gas.
It's not providing anyone in America with anything, is it? It's only providing people in Britain and Germany?
The natural gas is going to Britain and Germany, yes, Your Honor, but the record on page 6 indicates that exporting natural gas from the United States has economic benefits within the United States. Now, my co-counsel will come before this court today and demonstrate how the Planet Protection Group's due process claims are both non-viable and present non-justiciable political questions. I rise to urge this court on the public trust and environmental impact statement issues to affirm both the decision of the Department of Energy as well as the lower court, because the public trust doctrine does not bar the Vandalia Riverfront property transfer agreement, and because the environmental impact statement met all of the statutory requirements of the National Environmental Policy Act. Your Honors, first on the public trust doctrine issue, there are two reasons why the public trust doctrine does not bar the transfer agreement at issue here. First, the public trust doctrine does not in any way place any limits on the state of Franklin's ability to transfer the Vandalia Riverfront property. And second, even if
what about the fact that the citizens have been using that property for recreational purposes for a number of years?
Your Honor, some states have recognized that land inward of the high water mark, of the high tide watermark, are protected under the public trust doctrine. But as a matter of federal common law, the Supreme Court has only recognized that the state must hold in public trust lands that are below the high water mark. So those lands that which the high tide hits, the waters below navigable waters, and the navigable waters themselves. Here, Your Honors, the appellants have pointed to this court nowhere in the record that indicates the state of Franklin purports to grant Mammoth Cove title to the navigable waters of the Vandalia River or the submerged lands that are under.
What about the fact that they have permitted, even though there's a fence around it and no trespassing signs, the record indicates that the access, limiting the access to the property has not been enforced, and in fact they've put up picnic tables in the area and people leave their kayaks and things there.
Absolutely, Your Honor, and Mammoth Cove does not contend this at all. But the issue here is that the public trust doctrine does not extend landward to lands that are above or rather do not extend past the high tide watermark. So actual land here, the 575 acres of the Vandalia Riverfront property simply are not protected under the public trust doctrine unless the state of Franklin extends the public trust doctrine to protect those lands. So for example, some states, such as the state of Pennsylvania, extends the public trust doctrine to protect the public's rights not only to access on navigable waters for commerce, but also for recreational purposes such as kayaking. Here, as the record indicates on page 10, Your Honors, the state of Franklin has no state law on the extensions of the public trust doctrine. Indeed, the state's Marketable Title Act does not even contain an exception preventing the state from transferring.
Is the Vandalia River navigable?
Your Honor, the record on page 4 in a footnote indicates that the river is navigable. So based on that wording in the record, Mammoth Cove would not contend significantly that the river is not navigable. But what is clear here, Your Honors, is that the state of Franklin is not wholly abrogating its sovereign powers over the river.
In the fact that you can't answer that question yes or no suggests that it needs to go back down to develop the record so that the evidence can be established as to whether it's navigable waters or not?
Your Honor, even assuming that the Vandalia River is navigable, the appellant's claims under the public trust doctrine.
So my point is that they want it sent back down so they could develop the record and develop evidence and put on evidence. We haven't got to that point, and you can't answer the question yes or no, is it navigable or not? So doesn't that lend credence to their argument that it should go back and develop some evidence?
Not necessarily, Your Honor, no, respectfully, because even if we assume for purposes of argument today that the Vandalia River is navigable, the only limit placed on the state's ability to transfer the Vandalia River from property would be if it purported to transfer title to the Vandalia River itself. And nothing in the record here indicates that the state of Franklin is attempting to give Mammoth Cove exclusionary rights to access to the Vandalia River. All that the record indicates on pages 3 to 4, Your Honors, is that the state of Franklin is allowing Mammoth Cove to simply build a pier on the Vandalia River so that it may conduct commerce. I can put my kayak on that pier? Your Honor, while there may be a hindrance on the ability of citizens of the state of Franklin to dock their kayaks to the pier.
I mean, counsel, this is a mammoth, operation. And once y'all are there, no one else is going to be able to use the river, are they? Or we don't know because there's not a record, but do you think so?
Your Honor, were the record clear that, so to clarify briefly, so the proposed site for the Mammoth Cove terminal is 3 miles inward on the Vandalia River from where it empties into a bay. Now, preferably, the record would be clear on whether the Vandalia River extends past there. So it's not clear, and the record is also not clear as to how wide the river is. So were those facts properly before the court today, that potentially could be an argument, but still, under the public trust doctrine jurisprudence, the only time a state violates the public trust doctrine is when it abrogates all of its sovereign powers.
I'm not sure I heard an answer to can Judge Abulhassan put his kayak on the pier or not?
Your Honor, even if the citizens cannot, assuming that they cannot moor their kayak to the pier.
So they cannot?
The record, again, isn't clear, and
okay.
And Mammoth Cove, I have not had those conversations with my client, Your Honor. But even assuming they cannot, the only limit the public trust doctrine places is that the citizens of Franklin must be able to access the navigable waters of the Vandalia River. And it must be made clear here, Your Honors, that the state of Franklin can still use its sovereign powers to regulate Mammoth Cove's activity over the Vandalia River. The state of Franklin could, for example, enact a law allowing only commerce during certain hours of the day, or they could only allow access to Mammoth Cove on the weekdays so that the citizens of Franklin may access the river on the weekends. The state is not abrogating its sovereign powers over the navigable waters of the Vandalia River, and for those reasons, the public trust doctrine is not implicated here. On the environmental impact statement issue, Your Honors, the Department of Energy did not act arbitrarily or capriciously in its analysis of downstream greenhouse gas emissions for 2 reasons.
What did they do besides adopting FERC's earlier analysis?
The Department of Energy, as it recognized on page 6 of the record, did two things. First, it added a supplement regarding some of the economic benefits of exporting natural gas as to the economic.
I think you probably concede that's not of extreme relevance here. What was the second?
Absolutely. The second is adding the life cycle report to the environmental impact statement.
But the life cycle report looked at an energy profile that really doesn't apply to Great Britain and Germany. Isn't that right?
In a way, it does, Your Honor, respectfully. So
regional coal, I think it's pretty clear that that doesn't apply to those two receiving countries. Your
Honor, while it may be true that that United Kingdom and Germany do not solely rely on coal to produce power, what is clear is that it's not reasonable to assume that that natural gas, which is a baseload energy source, is going to be used in these countries to offset intermittent energy sources such as renewable energy. Rather, what is reasonable for the Department of Energy to assume in its analysis of environmental impacts.
Why is Mammoth so opposed to remanding this matter so we can you can give better answers and so we can understand this better as a court?
Your Honor, the Supreme Court, in many cases such as Baltimore Natural Gas and Vermont Yankee Nuclear Power, recognized that the reasonableness requirement of the indirect effects requirements, so requiring only that reasonably foreseeable indirect effects are analyzed, are so that the administrative agencies are not overburdened with overemphasizing highly speculative harms. Because if we overemphasize harms that are too highly speculative, then that could potentially diminish the quality of an environmental impact statement here, Your Honors.
Isn't one of the issues here, though, that the indirect effects that were analyzed were only regarding coal, and there was no analysis by the DOE of the indirect effects on the renewables by the use of this facility?
Yes, Your Honor, and that leads me to my first point, that omitting the challenged deficiency of not including the potential for natural gas to compete with renewable energies. This court has held numerous times in cases such as Theodore Roosevelt Conservation and Wild Earth Guardians that if an indirect effect, in those cases the effects were cumulative, and there's still the reasonable foreseeability standard. But if an environmental effect is not reasonably foreseeable, then this court has ruled in multiple instances in those two cases that the entire omission of those effects from the environmental impact statement is not arbitrary and capricious. Because what the National Environmental Policy Act is designed to do, Your Honors, is designed to inform public decision making. And this court only requires that assumptions are disclosed when the effects are reasonably foreseeable, and that's what this court recently held in Sierra Club v. FERC. The case before the court today is much more analogous to Sierra Club versus Department of Energy, otherwise known as the second Freeport case. There, as this court recognized in upholding the Department of Energy's reliance on the life cycle report, speculating upon how natural gas will compete with renewables in a foreign energy market requires the Department of Energy to engage in such speculative calculations that it simply cannot practically inform public decision.
Seems less speculative to me to require that compared liquid natural gas to the renewables there than it is to compare it to coal here when it's not going to be used here, it's going to be used over there. It's more speculative to me to be basing it on the coal.
And that's what the Department of Energy did here, Your Honor. The Department of Energy, in its analysis of the environmental impacts, reasonably determined that the natural gas that's being exported from the United States is going to go to the United Kingdom and Germany to displace coal. And thus reliance on the life cycle report there is proper, because while the Department of Energy might not be able to specifically calculate the specific impacts of nullifying coal in those countries, the life cycle report, it has been deemed as a reliable source for estimating the impacts. And indeed, the life cycle report discloses all of the assumptions.
Who deemed it appropriate to use the life cycle report? You said it's been deemed an appropriate vehicle.
This court in the second Freeport case acknowledged and upheld the Department of Energy's reliance on the life cycle report.
But the circumstances weren't coextensive there, were they?
That is true, Your Honor, that there we did not know the precise countries that the natural gas was going to. But that difference, that factual difference is insignificant here, Your Honors. The second Freeport decision stands for the principle that requiring the Department of Energy to particularly calculate how natural gas will compete with renewables in a foreign energy market is just too speculative in nature. And the Supreme Court's decision in Baltimore Natural Gas and Electric is instructive here. There, the administrative agency created and relied on
How is what they did here not speculative also? How is using the life cycle report not also speculative?
Respectfully, Your Honor, using the life cycle report here demonstrates the Department of Energy's determination that the natural gas being exported is going to displace coal. And so by relying on the life cycle report, which assumes a regional coal, which in actuality overestimates how much coal is going to be displaced in the UK and Germany. So
are you saying that the use of the life cycle report is relevant and material because in looking at reduction of CO2 emissions, liquid natural gas will reduce those emissions vis-a-vis the coal?
Correct.
But that it's too speculative to look at what it would do vis-a-vis the renewables?
Correct, Your Honor, because as the record indicates on page 9, the United Kingdom and Germany only have commitments to increase the amount of renewables that they use in our energy market. It's not certain that they're going to continue using renewable energy sources. And that's how this case analogizes to cases like Theodore Roosevelt Conservation, where the proposed projects that were early on in their lives may not have actually survived on. And indeed in Wild Earth Guardians regarding the unreasonable foreseeability of proposed projects. The 11 projects that the challengers there wanted included in the environmental impact statement, only 3 of them actually survived upon the challenge project's completion. Here what we have is that it's not certain that the United Kingdom and Germany are going to continue their pledges to displace all reliance on coal and natural gas with renewable energy sources. And for those reasons, Mammoth Cove asks this court affirm the district court's granting of the motion to dismiss on the public trust doctrine issue, and affirm the Department of Energy's denial of the appellant's petition for rehearing. Thank you, Your Honors.
Thank you. All right, Mr. Barsky. Whenever you're ready.
Your Honors, and may it please the court, I am Jonathan Barsky, also representing the intervener, Mammoth Cove, on the due process issues. Your Honors, this court should uphold the ruling of the lower district court here, finding that the due process claim presented a non-justiciable political question because it presented an initial policy determination beyond the competence of the judiciary. Additionally, there are no judicially manageable standards with which to make such a determination of a fundamental right. However, if this court does proceed to examine the merits of the due process claim, it should still not enjoin construction of the Mammoth Cove terminal because there is no fundamental right implicated and the project easily satisfies rational basis review. To begin with the political question doctrines, Your Honors, the case of Baker versus Carr sets out 6 factors, any of which, as the circuit has reaffirmed in cases like Schneider, can be sufficient to dismiss an action, and 2 of those factors are relevant here. First, the third factor, that of an initial policy determination beyond the competence
Well,
of
if
the
it
court.
wasn't a political question in Juliana, how is it a political question now?
Your Honor, we believe that the Juliana court was incorrect to determine that no political question existed and would urge this court not to adopt that court's decision as persuasive authority. The 2 factors that were most relevant here, beginning with the third factor, that of an initial policy determination beyond the court's competence. And as other courts have recognized in similar cases like the native village of Kivalina case, as well as California versus GMC, the intense balancing between economic and environmental interests is not well suited for judicial review. Rather, those sorts of decisions are ones that Congress has delegated to the executive branch, which has the expertise and authority to analyze such a complex technical and scientific problem.
Well, courts decide complex, scientific, difficult questions all the time with using experts and discovery and other reports and things. Why can't we do it here?
Your Honor, even though the court might be able to gain light of some expertise through, for example, the trial process as opposing counsel has suggested, that would still be inferior to the expertise contained within the executive branch. This court, while may hear expert testimony, does not have regulators or scientific experts at its beck and call. It would be relying only on the information gathered by the parties. Whereas as the
court has the authority to appoint an expert to give it some level of independent advice, doesn't it?
Yes, Your Honor, but as the district court in the Comer versus Murphy oil case recognized, that capacity is still inferior to that contained within the executive branch. And furthermore, the second Baker factor is also implicated here, Your Honors, that of judicially manageable standards. While opposing counsel cited NEPA as an example for how this court could make a due process determination, NEPA is an entirely procedural statute, Your Honors. It does not grant any particular substantive outcome that should be completed at the end of the review process, and therefore would not guide the court in establishing a due process right.
What is the question that you say is too political for this court to be able to decide?
In asking for the right to a stable climate, Your Honor, the appellants here require this court to determine when the climate would become destabilized, how this project that they are challenging would contribute to that, and further determine that that destabilization, the net effect of a single energy project, would so sufficiently upset the balance of the climate as to become...
Isn't that a scientific determination?
I believe it is, Your Honor.
Well, then it's subject to discovery. I mean, it's subject to evidence and being able to weigh that evidence to make a determination. Why shouldn't we send it back to have that kind of expert information brought to us?
Your Honors, even with that sort of discovery, the second Baker factor would still counsel against this court taking that look, because the project would not simply require determining the emissions at issue in this case, but in finding a right to a stable climate, this court would have to look at all sorts of other sources, national emissions, emissions by other countries that are clearly outside the jurisdiction of any American court to control.
Are you disputing that we have a right to a stable climate?
Yes, Your Honor. In addition to believing that this is a political question properly for the political branches to decide.
Serious? You say we don't have a right to a stable climate?
Not one that is recognized as a fundamental due process right, Your Honor.
So the right to life, liberty, pursuit of happiness, I mean, we have that right to do that. Why wouldn't the right to have a stable environment, the right to life, be something that we have a right to look at?
Your Honors, in due process construction, the Supreme Court has instructed lower courts to first presume against a broad expansion of a substantive due process right. And the right to a clean environment, one free of pollutants or toxic contamination, has historically not been recognized by a single American court, with the sole exception of the Juliana decision in Oregon.
But can't we at least establish we have a right to have an environment where we can sustain life?
Your Honor, the question must be more specific than that. For example, in Glucksburg, when the...
Well, how much more specific?
In case law like...
half-life? Or...
Well, Your Honor,
so we aren't gasping for air, but we can take, 50-yard walk? I mean,
in many of these cases, Your Honors, the Supreme Court has narrowed fundamental rights being asserted. So, for example, in Glucksburg, the right was narrowed from a right to die to the right to die with means of assisted suicide. In Reno versus Flores, the right was narrowed from that of a categorical right of private placement for alien minors to one that allowed them individualized hearings.
So how would you narrow the right here, going back to Judge Alloy's question?
Well,
how would you narrow the right to life and the right to a sustainable environment?
Well, the record, Your Honor, indicates that unlike the Juliana decision, the petitioners here are not challenging the right to a stable overall climate based on the global content of emissions. Rather, they are challenging a right to a stable climate as against a particular set of emissions, that from the Mammoth Cove facility. And that is the properly narrowed version of the due process right being asserted. Now, Your Honors, case law highly, highly cautions against the expansion of this right, based on our fundamental history and tradition that the Supreme Court has recognized being the standard for applying new due process rights. In case after case, sister circuits, including the Third and Fourth Circuits and a variety of district courts, have held time and time again that there is no fundamental due process right to a clean environment, one free of contaminants or pollutants.
Should we be looking at this in the broad perspective that petitioners are urging, or for what it is, what it was before the agency, and that is one LNG facility?
I believe the properly narrowed version of the due process right would only be against the particular LNG facility as indicated in the records at pages 10 and 11. And there, Your Honor, we actually see a highly important distinction between the claim brought by petitioners and the one decided by the Juliana Court when they did find that due process right. The Juliana Court was dealing with a challenge to global emissions and a national failure to act against those emissions. And in making its decision, when it upheld the due process right against a motion to dismiss.
What's the harm in sending it back down to develop all the facts and circumstances so we can make a decision? I mean, right now the facility's not going forward, right? I mean, it is going forward, right?
It is going forward
right.
currently.
But what's the harm in delaying that to give an opportunity for them to develop the facts so that we can determine whether this right to an environment to where we can sustain life is a fundamental right or not?
Your Honor, the consequences of that decision, although it would, in this case, appear to be delaying one plant, would open the potential floodgates for a strict scrutiny standard to be applied in these cases. The logical endpoint of the plaintiff's claim that there is a right to a stable climate would require the government to have a compelling and narrowly tailored interest in undertaking any sort of project that could conceivably have an impact on greenhouse gas emissions.
But we don't really have to remand on that issue, picking up on what the court's been asking you. We could simply remand to for the purpose of having the DOE and the FERC analyze the issue, couldn't we? Without getting into the substantive due process question.
Your Honor, as I understand the relief sought by the petitioners here, the remand to the agency itself would only be to be considering the procedural violation of NEPA. That would not provide this court with any further information about how to determine if a fundamental right to a stable climate exists. But, Your Honor, based on the standards laid out by the Supreme Court, the fundamental history and tradition, there is no support for allowing such a fundamental right, and therefore it would not be necessary for this court to send that back to the lower court for further discovery. Furthermore, the Juliana Court had adopted an additional argument for this. It had argued that there was a federal version of the public trust doctrine, and that itself imposed a due process obligation. However, that distinction is equally inapplicable here. With regards to the property that was transferred, the land transferred by the state of Franklin was clearly not owned by the federal government, and so the federal government cannot possibly be the trustee there. The same equally applies to the submerged lands under the waters of the Vandalia River, which were not purported to be transferred at all. Furthermore, opposing counsel conceded that they are not attempting to create a public trust right to the atmosphere, which means the only public trust right that could possibly be asserted in this case is that over the oceans and how that would react with the effect of increased greenhouse gas emissions. But there are additional reasons for the circuit, based on its precedent, to not allow such a public trust claim to go forward. As this circuit, district court from the circuit in the Alec L. versus Jackson case ruled, which was later affirmed by the circuit in full in Alec L. versus McCarthy, there is no federal public trust doctrine. In PPL Montana, as recently as 2012, the Supreme Court found that Illinois Central Railroad, which is one of the central cases establishing the doctrine, was not a federal common law doctrine at all. It was simply a matter of state law. The Supreme Court later reaffirmed this language in cases such as Appleby versus New York, Phillips Petroleum in 1988, Idaho versus Coeur d'Alene Tribe in 1997. Every time it has found a new public trust case, when it cites Illinois Central Railroad, it refers to that case as a matter of Illinois law. And it would be highly illogical to say that a statement of Illinois law somehow created a constitutional obligation on the federal government.
What about the, excuse me, what about the public interest? Doesn't the Natural Gas Act require the DOE to make decisions consistent with the public interest?
Yes, Your Honor, and the record on page 6 indicates that such a public interest analysis was in fact carried out here.
And how is this decision consistent with this decision made by DOE, consistent with the public interest?
Because the emissions, as analyzed by the life cycle report, took account of the emissions that would be created by the exportation of natural gas and weighed that against the economic considerations, as detailed in the record on page 6, the financial benefits that we would be reaping from the creation and the exportation of natural gas. And the Department of Energy's regulators there, in looking at that complex array of interests, made a determination that the public interest criterion had been satisfied. And this court, in finding that a fundamental due process right does not exist, should be assured that there is a check in the form of the political branches. Their public interest analysis would be able to determine whether these projects are in the interest of the public. And if
Do we really have to answer that question in this case?
I don't believe so, Your Honor. However, if members of this court are concerned about the potential implications of runaway climate change, there are political checks within the system that would not require this court to take the extraordinary step of finding a new fundamental due process right. Additionally, Your Honors, there was a final argument mentioned in the Juliana decision that I just want to quickly address, that of the danger creation exception. The court there argued that by failing to act against climate change, the federal government was creating a danger to the citizens. That exception would not be applicable to the case at bar here because the actor here is a private party, and as the Supreme Court recognized in its DeShaney case, there is no due process right as against a private party when the government is not the actor causing the actual harm.
The government is permitting the harm to occur, if there is in fact harm.
Your Honor, the federal government would only be involved here insofar as it is involved in the licensing process, which is what the DOE's authorization was for. But the actual creation of emissions, which is the harm suffered by plaintiffs, would be solely the result of the operation of the plant by Mammoth Cove, a private party. And that attenuates.
Doesn't that argument state too much, because the emissions would never occur unless the FERC had granted the certificate of necessity and the DOE had granted the license. So it is completely regulatory. The regulation of all this is completely within the federal government. The state has been displaced with regard to that.
Well, the federal government is involved, agreed in the licensing decision, Your Honor, but the nexus between what is causing the harm may be the result of federal approval further down the line, but the harm is not coming directly from the state. It's coming from a private party, which
But
highly.
the federal government's obligated to analyze that before it ever allows the construction.
Yes, Your Honor, and as the record indicates on page 6, that analysis was undertaken by the DOE. It did the requisite public interest analysis to determine that the project could go forward.
But for the license, the harm couldn't occur.
Yes, that is true, Your Honor. However, there would still not be a sufficient nexus between the action causing the harm, the action that directly causes the harm, the exportation of natural gas and its eventual burning, and the harm suffered by plaintiffs. Your Honors, because no fundamental right exists, this project should be analyzed under rational basis review. And the economic concerns I discussed earlier provide a rational basis for the government to have approved that licensing decision. And even if the court is not satisfied with that information in the record, as the Supreme Court has noted, rational basis review can even include rational speculation as to why the government would have approved this project. And so long as the government's reasons for approving that project were not irrational, it should be allowed to go forward. Now, we respectfully believe Your Honors would not have to reach this point because there is a political question preventing this court from making that ruling. But if this court does reach that decision on the merits, rational basis review should apply. Thank you, Your Honors.
All right, and you have 2 minutes for rebuttal, Mr. Alves-Barros.
Your Honors, may I proceed?
Yes.
Thank you, Your Honors. I would just like to make 2 quick points. First one, as my co-counselor respectfully mentioned, he doesn't know whether or not Your Honor is going to be able to tie your kayak in the pier. However, we do know something about that the only reason for the pier to be constructed is to be used for huge gas tankers that are going to become every day in the river. Therefore, even if you're going to be able to tie the kayak there, you're not going to be able to share the river with big gas tankers. The second point, Your Honor, is also in regards to the NEPA. My opposing counselor mentioned that it's insignificant whether or not the gas going to be exported for England and United Kingdom is going to be used to facilities or other kind of business. However, USC 42, section 4332 CI statutorily demands that we must know the commitments of resource and where they're going to be disposed and exported to, and for which functions they are going to be used and implemented. For those reasons, Your Honor, we respectfully for reverse the Department of Energy and reverse the lower court decision. Thank you.
Thank you. All right, Mr. Diab.
Thank you, Your Honors. I have a few brief points on rebuttal. First, I would like to state that Mammoth Cove here has provided a number of case law in support of their case. However, they have failed to produce facts either distinguishing or comparing this case from those cases. A few, for instance, PPL versus Montana was an equal footing case, not a public trust doctrine case. In Juliana, the danger creation exception is an exception when to the general rule that government action is not required, affirmative government conduct is not required. However, we're not asking, as in Giuliano, to require agencies to set forth a full national policy. We're asking for them to refrain from, as Your Honor mentioned, the affirmative conduct of granting the permit.
How can you say if it wasn't creation of the danger, if there wasn't a creation of the danger in DeShaney, how in the world can you say there's one created here?
Your Honor, I'm saying that the danger creation exception is not applicable here because we're simply asking for an injunction. We're not asking that Department of Energy adopt a generally applicable standard to all of its cases. We are simply asking that this permit not have been granted. That is not an affirmative conduct. That is, in fact, an injunction refraining from conduct. I would also like to point that we are not asking for a fundamental right to an environment with no pollutants. That is a mischaracterization of our claim. That is not what we were asking for. We're asking for the recognition of a fundamental right for a climate system capable of sustaining life. We are also, Mammoth Cove has mentioned that NEPA procedure would not inform the court. NEPA procedure statutorily exists to inform the agency and the public. How can we then say it is not going to inform the courts? For those reasons, Your Honor, we respectfully ask that you remand this decision. Thank you.
All right, thank you. We'll retire to deliberate and let you know what we decide shortly.
Be careful, don't fall off again.
They're not part of the whaling, but front of.
Oh, so you guys get like a taste really. Now, are you a professor? Oh, right, because you're a practitioner.
I'm a friend of the school. I owe Loretta, who's our operations manager, 1,000 favors. And she asked for and that goes jump to the chance because it's just fun to be part of it.
Yeah, you guys have such a great environmental program.
Yeah, entirely.
As well as in there, that's cool.
Is that why you decided to go there too?
Actually, I'm not even from this. I was already in New Jersey before for college. So after that, I applied for some law schools because I was near New York.
Right, that makes sense. Excellent.
Yeah.
I'm just thinking it's like so amazing because English is your second language, or even, I mean, it's not your third language.
Actually, I'm born with it, but I went to Italy before I come to Venice.
You went to where?
Italy.
Oh, so Bonnie and Donna.
Okay.
Yeah.
Okay. So,
Dove?
Dove? Where did I go?
Yeah.
Non, Italia, però should be
The only one so we can
and I think really I thought those were all different. I miei piatti, il mio babbo era italiano.
Okay.
Mio,
All right.
mia lingua non è buona. È brutta. No. Yeah.
It doesn't benefit when you are not handicapped in other countries. You don't have to be like reading by hand everywhere. You know, complete yourself.
Did I stand up for you speaking Italian?
Oh, yeah.
I'm over here. But I was just impressed that you can argue in English so, I mean, beautifully. I mean, really well. And
I've been here for 6 years.
it doesn't matter.
It's still, yeah,
I took Italian for 11 years, so I couldn't argue that. It doesn't matter. It's like,
you keep getting stronger. So watching you start off stronger now.
I mean, like that you're here. It's impressive. Where, I mean, it's really impressive. I mean, it's impressive that, I mean, you do it in a language that's not going to be sideways. Like, daughters will expect me to go to movies. I might have to leave and not even find out. I know, but I promised them I would be there at 4:10. And I can still get there, so maybe I'll just be a little late.
There's always, 20 minutes of preview.
Yeah, exactly.
Which movies?
I don't remember which movie. I'm finding out. I'll know when I get
That
there.
might make the decision.
No, I have to go. It's the other judge also is going to be there with his family, so I should. I'm a private professor, yeah. No, I can play
Oh, it plans to happen
Briefly, brief down to studying a little bit of that. Haven't been interested in it. A little bit of touch into
Coming back right after this.
this year.
Oh, so you should then do, yeah.
You guys get right at us.
Discord manager, our
It's exciting.
engineering professor, is from to the teacher, which is funny because
It's personal subject, and it's right.
they've practiced it and litigation, and they're both professors of
She's got long blonde hair that.
Just a moment for me. They're tallying right now.
Are you talking about Ann Powers? Because she doesn't have any.
They're tallying scores.
No,
It's exciting. Have you taken that law?
Yeah.
I never took that.
I didn't either. I don't have
Ann
to.
something. I went to law school with her. She was a case anyway. Ann something. Ann without E. She spells it
Very
wrong. Yeah. Let me see, case law faculty.
We had Dr. Rose Fetter. She was cool. But yeah, I think she changed her name. Well, I think that she. No, I'm thinking of something.
Her name is Ruben.
Tamara Griffiths Fetter. Yeah. No, I thought she was. I may be wrong.
Yeah, she was our
My
one
ex.
yeah.
Writing. I met her with a lot of officers.
She's half for she's finally. Oh wow. It was like 8 to 1st, top 16. Yeah.
That's what I like her so much, that started a little against her, because I know that clearly I deserve those grades.
And I mean, she gave lower words. She's like that.
please be seated. All right. Sorry, it took us a little while. This was a tough deliberation. All four of you all did a fabulous job, as good as and better than most of the lawyers I see in the Fourth Circuit. So great job. It was close. But the winner of the WVU College of Law Energy and Sustainability Moot Court Competition for 2018 is team number 8. And I don't know where y'all are going. Mr. Wood and Mr. Marcy. And we're going to make a few comments, but first, I think we'd all like to know what schools you all are from so that we can recruit you.
We're from the William and Mary Law School, Your Honor.
All right.
Pace Law School, Your Honor.
Pace. I was just at Pace a couple weeks ago.
Yeah, I'm there.
Yeah. All right. We'll start with Judge Appellant.
Well, let me congratulate you all for being in the finals. I mean, reading through the material just to get ready for today made my brain melt, okay? Much less be able to stand up here the way you all did and talk competently about it. I mean, my questions weren't all competent because I just didn't know it the way you all did. I thought one interesting time that took place was when a question was asked, and what do you think? And you said, well, it's not what I think, it's what NEPA thinks. And I thought that was a very good response. I noted that down in my notes because I thought that's a very excellent way of taking that question going, it's not what I want, it's what the law requires. I thought you did a very good job in that regard.
Judge Alloy?
I agree with the comments. All of you are excellent, and you should be proud of the work that you've done. And you do all the right things. When you answer questions, you stay away from it being personal. You focus on the law, you focus on the facts, you focus on cases that will help the judges make the decision that they need to make. And so I guess how I measure something is at the end of the argument, do I feel that I have the information that I need to make what is a hard decision? And I think you all did that for us. So it was really very impressive, and we thank you very much.
Judge Volk?
Thank you very much, Judge Thacker. What I would say, a lot of people want to know what happens back in chambers and, how judges make their decisions, and I'm going to tell you something very important today as to how I would have dealt with this if I were an appellate judge. So if these briefs came in my door, it wouldn't take me very long in reading them to realize I would want to find a way to recuse myself. It is a very difficult question, exceptionally difficult. And I would say your passion and ability to stay on message was exceptional. You did a fine job in that regard. And I would tell you that I almost thought that I was dealing with a law professor. I had some questions about the particular areas that you were dealing with, and you gave me a confidence that you had it right. And a lot of times I try to second guess and play devil's advocate, but you really restored the lack of confidence, or you restored my confidence in your side of the argument, because I was a little bit dubious, to be honest with you, so you did a fine job on that. You were just unflappable and consistent. I was very impressed with your ability to transition back to the argument when questions were asked, and there were no softballs that came your way, and you handled them all respectfully and very, very capably. And I would say something I mentioned to the judges back there, they said of Billy Graham that the way he talked, his cadence and delivery, even if you disagreed with him, you couldn't help but listen to him and capture what he was saying, and you really had that gift. The way you proceeded through, and you also got some exceptionally difficult questions. Your transition back to the argument, I thought was very well done indeed. None of you have anything to be ashamed of. You did an absolutely spectacular job.
Judge Keeley?
I echo all of the comments of my fellow judges, and when I looked at my notes on all four of you, it's fantastic knowledge of the case law, but beyond that, you were able to drill down into not only the facts in those cases, but you could drill down into the regulations, the statutory and the regulatory sites, and your ability to distinguish with all of that for our benefit was I thought, with regard to all four of you, rather incredible. These scores were very, very close, and I would say one thing, that when you have all the judges jumping down your throat about the creation of a substantive due process right, the answer is, but judges, you don't need to go there. and get yourself out of it as quickly as you can and as best you can. But on rebuttal, you all were incredible. You know, you were able to get up there and just hit the home run on each of the points. I just felt incredibly privileged to be here and to listen to these arguments. And as a district judge, I would say to you that this case is probably very timely. At least here in West Virginia, we're seeing an awful lot of energy law coming before the district courts. I said when I started out as a judge many years ago, I was doing a lot of strikes, union strikes. And I'm in the more twilight years of my career now, and I'm talking about FERC almost every day of the week, it seems like. And so, but not on these overarching issues, but certainly on pipeline and transmission issues. So, you know, think about what this case is, and remember that these questions are likely to be decided by courts very quickly in the next couple of years, I think. They really, when I was reading through it, I thought, boy, this tees up everything that's going on.
I, of course, agree with the rest of the panel that all four of you all were fabulous. I'm sure that your professors and coaches tell you that you should welcome questions from the court. And I've never seen four people that actually seem to welcome questions from the court. You really, we ask questions because we want to know the answer, and because, you know, sometimes we may be trying to help you. And you four did something that apparently is difficult for a lot of litigants, and that is you listened to the questions, you answered the question, and you answered the question that was asked. Now, that may not seem so difficult for you all, but we regularly see it as a challenge to people that argued before us. I had a case when I was early on the bench where it was a cold case, and so I knew that my fellow panelists, since I'm from West Virginia, were probably going to make me write this, and it was a horrible, boring case, contract case. And nobody had talked about in the district court below or in the briefs or in the argument about paragraph 18. They were focused on paragraph 8. And paragraph 18, I thought, could help the appellant win, clearly. So I was trying to understand it because, again, I was going to have to write it. And he gets up there, and he starts in on paragraph 8, and I said, well, but wait, I think I can help you. What about paragraph 18? Doesn't it say blah, 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 whatever it said? And it was probably blah, blah, blah. And he said, paragraph 18? Yeah, paragraph 18. Wait a minute. So he walks back. Now, he had nothing at the podium with him, so he walks all the way back to the table. Oh, great. He's going to go get paragraph 18. No, he goes back, and we have smaller bottles, but bottles of water everywhere, and he stops, and he opens his water, and he, okay, and everybody, it's just tick, 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 and he stands there, and he drinks the entire bottle of water, then he comes back, notably with nothing in his hands, no contract, and then he looks at me, and I look at him, and I say, well, and I said, what about paragraph 18? And he said, I don't want to talk about paragraph 18. I want to talk about paragraph 8. And I just threw up my hands and said, well, I can't help you then. And he lost. So it's good to listen to the question, answer the question, and answer the question that was asked. And you all did that very well. So congratulations to both teams. And it was a pleasure to be here.
Thank you for the opportunity.
All right. Do you all want to
Following Fourth Circuit
do
tradition?
any pictures or? Yeah, pictures.